and welcome to tonight's discussion. Having learned some lessons over the years of, especially the last 2 years of doing these programs, is there's lots of questions that you want answered. And I think one of the easy things to do while we wait for everyone to come on board before we kick off, if you've got questions, pop them into the chat. We'll keep watching this chat as we go through and try and answer as many questions in real time. So if you've got questions while you wait and you're starting to get ready and we're prepping, feel free to put those questions into the chat. Jackie and myself will be able to pull out these questions as we go through and answer as many of them as we can.
Okay.
Thank you, Brad.
Sorry, Mark.
All right. Jax, if you wouldn't mind just minimizing your chat box, which is appearing on the screen, and then I'm going to kick off and just welcome everyone in.
Okay. If you don't mind, I am just trying to navigate this. There's a lot of cursors moving over this stop share hide mark here. Let me try again.
All righty. Sorry, everyone. We're just having a few technical difficulties, but we'll kick off shortly.
Let's see.
Okay, MJ, how does that work? Okay, great. I think we're ready to rock and roll.
We are. All right, so thank you all for attending the Genoa CPD event this evening on the Protection of Personal Information Act, or POPI, or POPI, whichever acronym you would like to use. My name's Michael Demant. I'm your host for the evening. I'm a director of Genoa Underwriting Managers, which is a medical malpractice provider. We insure thousands of professionals across the country in multiple disciplines. And yeah, I'm very pleased to announce that I'm joined this evening by two of my colleagues, Dr. Brad Byram and Jacqueline Smith, both of whom are experts in the field that they'll be addressing us on this evening. Over the course of the evening, for anyone who's a latecomer and didn't hear Brad's address, please will you use the chat function to place your questions in there this evening. And in real time, the speakers will attempt to address any questions or concerns or queries that you may have. So without further ado, we're all here to listen to Brad and Jackie speak this evening. Sorry, just final bit of protocol before I hand over to them. A big thanks to AHPCSA for allowing us to address all of its members this evening. And finally, please will you keep your microphones muted until such time as you would like to address a question. With that said, I hand over to Jackie and Brad. So enjoy the presentation, everyone.
Thanks, MJ, for the welcome. Thank you for this opportunity to address you on this important piece of legislation, POPI, or POPIA, as it's interchangeably used. Let's kick off. Right, so POPI was enacted in 2013 already, with an indication from our president as to when it will become effective. And the reason why it's taken almost 7 years to become effective is because certain provisions were brought into effect first and others waited till a bit later. And so these provisions that we're going to discuss this evening are those provisions creating compliance, which actually came into effect on the 1st of July 2020 already, but we were given 12 months, 1 year, to comply, which takes us to today's date, 1 July 2021. So before I start sharing the slides, I thought we could just have a little chat about why POPI was necessary. And you'll be happy to know that a lot of you are already practicing POPI. You are already complying with the conditions for lawful processing of information in your professions. Right, so the main reason that POPI was enacted was to give effect to the rights which citizens and companies have under our Constitution to certain rights in the Bill of Rights, and those being Section 14, that everyone has the right to privacy, and this includes the right to protection against unlawful collection, retention, dissemination, and use of personal information, and that the state must protect these rights and fulfill the rights in the Bill of Rights, okay? Then Section 32 of the Constitution, which says everyone has the right of access to information held by the state or by another person, being yourselves, that is required for the exercise or protection of any rights. So how do we do this? Well, the legislator enacted PIA to give effect to Section 32, and I just want to pop back to that slide. Section 32, the bottom one, PIA implemented a process so that everybody could have right to access to information, and POPI has been implemented to give effect to the right to privacy. So POPI ensures that all South Africans, businesses, and private persons conduct themselves in a responsible manner when collecting, processing, storing, and sharing of another's personal information by holding them accountable should they abuse or compromise this information in any way. And of course, to further enhance PIA, and that is to remove impediments to the free flow of information, including personal information. Now, we said earlier that you are already practicing a lot of this. And Brad and I have extracted some legislation here to show you in what respects you are already complying. Firstly, there's the National Healthcare Act, which makes it an offence to disclose patients' information without their consent. Then there's the National Patients' Rights Charter, which says every patient has the right to take part in deciding on matters affecting their health. And this includes the right to complain about health services and have complaints investigated. Then there's PIA, which we chatted about, which directs how information may be accessed for the exercise or protection of any rights. So POPI complements the existing legislation governing your profession and the Charter. POPI doesn't replace the AHPCSA's guidelines or legislation. It augments these. And we've extracted some booklets which refer to these lawful processing requirements which you are already practicing. Number 2, 3, 4, 5, and 9 are the booklets in question here, as well as the AHPCSA Code of Ethics. So if we look at the preamble of POPI, the important information to take away from tonight's talk is that POPI promotes the protection of personal information used by public bodies, which is yourselves, and public bodies, but private bodies, meaning yourselves. It introduces certain conditions to establish minimum requirements for the processing of personal information. It provides for the establishment of an information regulator, because if we have all these laws, we're going to need someone who's going to be able to ensure that we are complying. And then it also provides for the issuing of codes of conduct. So most businesses are going to approach the regulator at some point and ask the regulator to have a look at codes of conduct which pertain to their professions or businesses and to comment on them. And in this regard, the regulator is going to necessarily have to be approached by the AHPCSA. Right? POPI also provides for the rights of persons so that they don't get unsolicited electronic communications and not affected by automated decision making. POPI also regulates the flow of information across borders of the Republic. Brad, I'll hand over to you to discuss the importance of personal information and the types you come across.
Thanks, Jackie, and hi, everyone. So the thing about personal information, which I think is important for us to recognize, is personal information is regarded as special information, and it's regarded as protected information. So we deal with that every day. So we go back and we talk about this, and we talk about it in a little bit of context that I want to create for you. The first is the National Health Act. It says a healthcare user, and that's not only your patient, but also your patient's family. A healthcare user has the rights to autonomy. And in the rights to autonomy, they have the rights to decision-making, which is what consent comes out of. They also have the rights and the expectation in your ethical conduct that you act well and in good nature. In other words, you act with beneficence and non-maleficence, so you don't do anything harm. But they also have the rights to justice. And the reason that I give that, and you all know this, is as we then go and we look at the Allied Health Professions Council, and welcome again to the registrar who's with us today. When we look at your Code of Ethics booklet, a lot of the messaging in that booklet is how we conduct ourselves as a professional, how we conduct ourselves in terms of our colleagues, our professionals who registered with the Allied Health Professions Council, and those registered with the Health Professions Council, and those outside of healthcare, but also then how we respect, from a constitutional view, the individuals that we work with. So when we get now into personal information, that is any identifiable information that relates to an identifiable living natural person. It can also speak to an identifiable existing juristic person. And a juristic person, if you're working as an incorporated business, and there's a collection of you, or a multidisciplinary practice, or you're running a clinic, and that clinic or that health center has its own identity. That identity and how it behaves becomes personal information in terms of that definition. But here, when we talk about information, we're talking about information that relates completely to your patient, to the user. And that includes race, gender, sex, pregnancy, marital status, etc. And you can read it all there. This is not our interpretation. This is the direct extraction of the definition of personal information in the Protection of Personal Information Act. You will see there that it makes reference now to things around ethnicity, social origin, color, sexual orientation. And I was explaining to Jackie and MJ earlier that my electronic record system not only has sex as several different identifiers of sex, but it then also asks about the identifier, how the patient identifies themselves. So when we start looking at personal information, we also, when we're doing our case history and we're recording our patient experience in that therapeutic environment, it includes what the patient believes, what they are conscious of, what their concerns are. It also relates to their level of education. It relates to their medical history, their financial history, including the consent that they've given you. If you've made reference to criminal history or where they work, it includes all of that. And then it includes any identifying number or symbol. Now that may include your IP address from your handset or from your laptop, your computer, your telephone number, your location information. You'll notice sometimes when you use an app, it says, we'd like to use your location. Any online identifier, which includes your email address or anything that can assign. Now, one of the questions that's come through now is, what about metadata? Do you need consent to use people's information as metadata? Now, the thing that's important here, and I'll answer that in a moment. If you're using an email address and you're using that consistently and it's provided by a service provider, as long as that service provider is maintaining their data integrity properly and managing their cyber risks, doesn't matter who your service provider is. There's no restriction that says you have to use service provider A over service provider B. You can use multiple ones as long as you're using the same one in a professional manner to conduct your professional business. And there are certain acts and legislation around that as well. Jackie, could you go on to the next slide just for a moment, please? Personal information also includes the opinions and views or preferences of the person that you're working with and the person that you're treating. And then it includes all correspondence sent by that person to you or sent by you to that person, either that is explicitly confidential, where they've said this is confidential, or it is implied that it's confidential. So if you're communicating and you're using SMS or you're using WhatsApp or you're using a social media platform, all of that content would be regarded as personal information and it would regard it as being needed to be protected. Equally, if I have a view on you and I record that view, my view of you becomes your personal information as well. And then the name of the person as it appears with other personal information relating to that person. Now, the reason that this is all important is because individuals in your practice, you've recorded their information in different ways. You've recorded their demographic or patient intake information. You've got their financial and billing information, and then you've got their treatment information, including, but not limited to, any other therapists, practitioners, registered healthcare providers. All of that forms part of this. Now, where POPI brings the rest of the world into line with what healthcare professionals have been doing is we've been obligated since our registration and since our acts were first formulated to act in a manner where the personal information that we hold from a patient needs to be managed with confidentiality, and it needs to be disclosed in a certain way. It also, our acts have said, we need to store information in a very specific way. So the storage of information from the 6-year minimum period required from when you last saw a patient to the 20 years if you're providing COID-related and injury on duty work, to the infinite storage of a person who's incapacitated, to the storage of 18 years plus 3 years in the event of a minor. Those are all stipulated in our requirements as healthcare providers. So none of that for us is new, but for many environments that became new. And so the challenge with POPI is if you're using the information for anything other than that person's direct clinical care, you now need their express written permission. So if you're taking all those email addresses as an example of all of your patients, and you're creating micro groups on Facebook or on Pinterest or on any other social media, these are those things that are important. So I'm going to hand back to Jackie now. She's going to take you through the requirements.
Right, so I thought we could just start by having a look at some of the definitions, because then we can say, who are we all in this big play of POPI? Data subjects, obviously the person to whom the information relates. So this would be the patient, or it could even be a staff member if you're collecting information, or it could be about another practitioner, okay? Responsible party means a public or private party which determines the purpose and means for processing the personal information. So you as the practice are the responsible party for collecting this information, but your practice management company might be a responsible party in relation to the information that it collects from you. And an HR administrator or SAGE, for example, is another example of a responsible party that is in possession of perhaps your staff's information and is a responsible party in relation to the information provided by you about your staff to SAGE. Operator means someone who processes personal information on behalf of a responsible party or for a responsible party in terms of a contract or mandate. So prime example of this would be staff, again, who process information on behalf of the practice in terms of the employment contract with the practice. Okay, processing means working with personal information, including the collection, receipt, recording, organization, collation, storage, updating or modification, retrieval, and use of information. So processing is quite a wide term, and it relates to almost absolutely everything you can do with documentation. Record means regardless of any form or medium, so that could be WhatsApp messages, SMS, written, clinical notes, any information which is written, produced, recorded, or stored would fall under this definition. Right, so one of the questions we get a lot is, can a patient's rights to privacy be limited? Like, do I have to share everything? Well, the Constitution says that you can limit rights where the limitation is reasonable and justifiable. So to determine whether a limitation is reasonable and justifiable, we need to consider the following. What is the nature of the right? That would be the privacy of the communication, okay, the personal information. Do I need to hold it confidential? Yes, I do. What is the importance of the limitation? Do I need to give accurate and appropriate health care? What is the nature and extent of the limitation? The retention of records versus the rights to have a record. The relation between the limitation and its purpose, they're often very closely related. I need to retain them for a reason, to provide you with healthcare. And are there any less restrictive means to achieve that purpose? And I've got there maybe none, because often more than not, we need everything that we have in our record in order to treat the patient. So tonight we're going to discuss the 8 requirements of POPI, and those are the provisions which create compliance. And we are enjoined to focus on all of these and to implement all of these conditions in order to be compliant. So let's start with the first one, accountability. Does POPI apply to me? Yes, it applies to all medical practitioners because you're private bodies. And if one looks at the definition of a private body, it says that it's a natural person who carries or has carried on a business or profession, a partnership which carries or carried on business as a profession. So POPI affects all private and public bodies that process information. We've already gone through the types of information. Okay, and POPI says that a responsible party, you must ensure, not you may, you must ensure that the conditions of the Act are complied with from the time that you determine the information's purpose and during the processing itself. So there's an obligation on you in terms of POPI from beginning to end. So if we look at the processing limitation, the key words extracted from POPI here are minimality and consent. So you only want to collect what you need to treat the patient and in a manner that doesn't infringe on the patient. You also need consent so that you are able to justify the information that you hold, and this burden of proof will be on you. You should collect directly from the patient where possible, except obviously where public records are made available or there's been a deliberate share. Purpose specification, we all know that in order to comply with this, we need to collect for a specific purpose, not for our amusement, to treat the patient. And as Brad mentioned earlier, you have already been complying with these retention periods contained in the AHPCSA guidelines. So now POPI says we need to make a patient aware of what information we hold and in terms of what legislation, and this would be contained in your consent form. In your consent form, there would be a clause to say that I'm holding information on your behalf. If you give me any misleading or inaccurate information, this could be hazardous to your health. I'm using this information. I'm taking a medical history for a reason, and that is to diagnose, evaluate or treat you. Okay, so, and you would also in your consent form ask the patient to, or make them aware at least, that you may be sharing RCD codes with a medical aid scheme. So in the Genoa consent form, if you haven't got a copy of one of these already, there's actually a clause in there that asks the patient to tick each and every block where it would give consent to providing information to a third party. Right, so I'm not going to go through this slide again because Brad's already touched on the minimum prescribed periods, but it is a very nice reminder to have because, we always need to turn back to it. Every situation is different, and sometimes it turns out that it's just a patient that came in for regular treatment, and it could end up being something that you need to, a reason that you need to retain the medical records for longer. So you can go and have a look at those in your own time. Further processing. However, this is another condition of POPI, is where personal information is received from a third party and passed on to the responsible party for further processing. So like we discussed earlier, it would be from the practitioner to the practice management company, or from a practitioner to a specialist. Okay, would further processing expose you anyway? This is what you need to figure out. Is it compatible with the purpose? Are you passing on the information in order to bill or to refer the patient? Was the information collected in the first place for the right reason? What was the nature of the information? Was it given to you voluntarily? Was it obtained involuntarily? The manner in which it was it collected from another healthcare practitioner, or was it collected from the patient? And then you obviously need to look at the rights which are in your contract, doctor-patient relationship, and obviously what the patient has signed and agreed to. Brad, I'll hand over to you for the importance of the information quality.
Thanks, Jackie. We speak a lot about this issue of information quality. And one of the things, and I see there's questions around where can we get a copy of the consent form? And I know that Michael Demant in his closing will share ways in which that can be communicated. I think when we talk about information quality, there's some reference that I want to share with you. And again, the first place of immediate reference that you need to go to, and we work upwards and downwards here. So in terms of your therapeutic relationship and your therapeutic mandate and the profession that you are registered with the Allied Health Professions Council to do, Your information that you gather needs to be consistent with your scope of practice and meet and preferably exceed the information that you need to be collecting. Now, there's a statement that when we talk about information quality that says, what would the reasonable practitioner do? And that would be a reasonable practitioner with the same or similar training to you, treating the same or similar patient in the same or similar conditions. So when we look at this, we say sometimes what happens is you create an error by omission, which means you've done something because you've left something out. So when you're collecting your healthcare information, or your patient or your user's healthcare information as a therapist or practitioner, you need to ensure that the information that's coming is as thorough as it can be. And not only is that bound into your training and into your professional registration with the Allied Health Professions Council, but it's also then bound into the act that governs you, and it's bound then into the National Health Act, and above that into the Constitution. And the second part to that, if that's part one, the second part is there's something called the National Patient Rights Charter. And that Patient Rights Charter gives the patient certain obligations, and it gives them certain rights. And some of those rights is access to care, treatment with a known practitioner, highest quality of care available. But they also then have the rights to confidentiality, they have the rights to autonomy and consent, but they have the obligation to do full disclosure of information. Now that creates a little bit of a challenge for you because the patient might not know what's relevant to them. So you need to be asking that patient as much information as you can. Now there's times where the patient might be a minor and they can't give you all the information that you need. Then you need to get information from their parent, or if not their parent, their guardian. You may also need to get information from referring professionals, and you need consent from the patient to be able to get that. So you need to make sure, as the responsible party, that the reasonably practicable steps, and those are very important words here, reasonably practicable steps have been taken, that the information is... Go ahead,
Thanks,
Jackie.
Brad. Just on that point as well, is the National Patient Charter, the actual words that they use in there are that you need to give full and accurate information. So even that enjoins us to take down information very carefully. You need to give full, accurate information about illnesses, diagnostic procedures, proposed treatment, risks, and costs. So there's quite a lot that we need to obtain, and it needs to be very, very accurate. And as you mentioned, getting it from the patient firsthand is the best way. Then on the next condition for processing information is the need to be open about the information. So we need to consider some things like, where did we collect it from? What is the source document? So in this case, you'd use your consent form, or if the patient was referred to you in the case of a specialist, you would use the information provided to you by the first treating practitioner. You would need to provide your name and address, that goes without saying, in order to treat the patient. And you'd need to say, what is the purpose that I've collected this information for? What is the law authorizing the collection? We've already spoken to those about being the ethical guidelines and the National Healthcare Act and the Charter. Okay, if you intend to transfer the information, have I obtained consent from the patient to do that? Has the patient got a right in all of this to rectify the information if it's not been collected correctly, or if it's incorrect, irrelevant, or excessive? And obviously the patient needs to be able to lodge a complaint should it not be he or she not be happy with the information and the way or the fashion in which you've collected it. So that is all about being open and transparent in your communications with the patient.
Jackie, before you go on, if we just go back to that previous slide, I think there's something that is fundamentally different that POPI brings into our lives that wasn't there before, and it is the purpose for which the information is being collected. In the past, it was implied that the information that was given to you, you could use in the way that you wanted to use. And people used that sometimes to advertise events, or to advertise products, or to on-sell that information, and by correlating it and then sending it off to a third party who would then motivate. So I think what you need to be aware of is, if you're intending to use the information that you collect from a patient, their ID number, their address, their location, their gender, their email address, for anything other than the therapeutic contract that you're entering into with them. They need to be made aware of that prior to you being able to use that information. Jackie?
Correct. Thanks. Then we move on to the second to last condition for the lawful processing of information, that is security safeguards. So as a responsible party, you must secure the integrity and confidentiality of the personal information in your possession by taking the appropriate technical and organizational methods to prevent a loss to patient information or from a person gaining unlawful access to this information. And how you can do this is by taking a look at your practice and seeing what are the reasonable, foreseeable internal and external risks in my practice? Do I perhaps leave files on the reception desk in between seeing patients? Are my staff trained and told that that might not be appropriate and that they should rather leave it on their own desk and only bring it up to the top of the counter when the next patient presents at the counter? Have I established safeguards? Is my IT sufficient? When patients use the internet to communicate with me or to make appointments, how secure is their data? There's a thing called cookies. They're a terrible, terrible thing that they, sorry, my light's just gone out in the office and I need to wave my hands
well, Jackie,
to get the light.
While you switch your lights back on, I'll answer the question that came through. Is verbal consent in the consultation sufficient to satisfy POPI requirements for a referral letter to the specialist? So verbal consent is fine. What you then need to do is you need to record in your records. I spoke to Brad about referring to Jackie, and Brad consented during the consultation of the 1st of July at 1835. So you need to bear in mind that everything that you do where you get information needs to be linked back to something that's in your records. We often find, and Jackie will attest to that now that she's back, is where this is challenged during a medical legal issue or during any other kind of legal challenge. They talk about the cold, hard facts of the law. And if it's not written down, it's very, very difficult to be able to explain it, because you'll say, well, Jackie said I could do this. Jackie says, well, no, I didn't. And then you find yourself toing and froing. So the more detailed your notes are, the more contemporaneous those notes, and the more diligent you are about recording what you agree upon in that therapeutic session, the more compliant you become. Jackie, back to you.
Correct. So back on the issue of security safeguards, you need to update your response to new risks. Obviously, with any business, new risks are going to emerge as you evolve. You might become a practice that moves more towards electronic records versus the good old filing cabinet. So you would need to review those all the time. POPI is an ongoing thing. You need to keep evaluating the risks in your practice. Right, so the last one is obviously data subject participation, and we have already seen that the National Patient Charter says that patients can have this right to decide on matters affecting their own health. So this is, again, not a new thing. You've been doing this for some time already. But for sake of completeness and just telling you what POPI says on this issue, the data subject can request the responsible party to confirm whether it holds personal information about the subject. What it says is that the request for the information that the party holds let's start with this. The patient can ask you for data. You can go and confirm if you hold the data, and that process is free. But the moment you are required to reproduce a record, you will be allowed to charge a fee for providing that record.
Yeah, Jackie, on that note, some of the questions that have come up from practitioners over the last few weeks as we've been having these discussions is, well, what happens if the patient owes me money? And now they want a copy of their records, but they still owe me money. And the answer to that, and I stand corrected, and Jackie and I struggle with it sometimes, is you can't withhold their information from them if they lawfully ask it. There is a process that they need to ask, and they can request in writing. You're obligated within 30 days to provide them with the information that they're requesting from you. Jackie, just touching that back to you.
Yes, no, absolutely. Once a patient has made a request for patient records, you have up to 30 days. That's deemed a reasonable period to get back to them. And obviously there's a procedure. That's why PIA is in place to make application on a Form C relating to private bodies as to what information they request. Then you get the 30 days to decide whether that information should be provided or not. And obviously you shouldn't withhold it unreasonably unless there are justifiable reasons. And we would look at then who's asking for it, what entitlement do they have to the information, what is it that they're trying to use the information for. All right. So then lastly, POPI talks about the appointment of the watchdog, the information officer within the organization. And so every business needs to have an information officer who is responsible for ensuring that the practice complies with POPI and PIA, because if you have a look at POPI, it actually refers to PIA in a few places. So it's important that the two pieces of legislation are actually read together and implemented together within your practice. And of course, once registered, you would, we've actually got a link you can go on to. Brad and I have checked, it takes less than 3 minutes to register a party with the information regulator. So I know they are having a technical glitch at the moment, and there was a notification that went out that said there will be no deadline for the registration of ROs and DROs, Deputy Information Officers, because they are aware of these technical glitches. So if you are having an issue, don't panic, because as I said earlier, you are already very compliant. Right, so what can the regulator do when it is notified of a breach? Well, it can refer the complaint to its enforcement committee. It can action it, so it could conduct an investigation. It could advise the complainant and yourself of the course of action it wants to take in relation to the matter. It could help settle a complaint between the parties. It could issue a warrant to enter your premises, but it would have to give you 7 days to have access. It could also issue you with an information notice telling you what action it requires you to take, or it could issue with an enforcement or stop notice. And lastly, it can obviously fine you. So we know that you would have seen in the notifications that came through this past week, well, if you haven't, I know everybody's been inundated with information, but where you are wanting to store information under special circumstances, you would have to apply for this consent from the information regulator, and they've also extended this period until February 2022. So we can see that the regulator is also inundated with queries, and its portal's going wild at the moment. So don't stress too much about that. But once you have asked the information regulator to decide whether you can hold the special information that's going above and beyond the information that you already hold, then they should do that within 13 weeks. They should come back to you as to what their decision is. All right, and that concludes our chat on POPI, and we would love to take your questions. So starting with the first question, where can you get a copy of the consent form? You can send your emails through to claims@genoa.co.za, and we will send you a copy of the most up-to-date consent form, including one that has a POPI clause in it. Any other questions?
Jackie, there's a couple of questions here, and maybe I can take a stab at answering some of them. There's the first question that's come through recently was, what is the guideline for practitioners using instant messages and WhatsApp with patients? And you need to consider, if you're using a tool like instant messaging or WhatsApp, that you're now communicating in a broadcast type of environment. And I know through the AHPCSA, you've got your ethics program that's run by Aroma SA. One of the readings on that speaks specifically about how to manage WhatsApp, and is very insightful and gives some guidelines. But some of the short answer to that is, you need to recognize, if you're using your mobile device or you're using your handset, you need to separate out, in the perfect world, what you're using for your personal lifestyle and what you're using for your clinical therapeutic lifestyle, because one relates to you as a professional and the other relates to you in your independent social identity. And you want to keep those separate from each other. So if you're using WhatsApp, whilst I can't give you any specific guidelines, I would say the first thing is recognize that WhatsApp should be a business WhatsApp and not a personal WhatsApp. The second thing is recognize the risk that when you broadcast a person's information, practically, you need their written permission to share that information outside of your therapeutic environment. When you're writing a referral letter, you're writing a referral letter in a very specific forum to a specific individual. If you're on a WhatsApp group, there is often an administrator to that group. You and that administrator and everyone else is directly, or what they call jointly and severally, liable for the content that goes out. And you need to make sure not only that the patient is aware that the information is being shared, but how it's being shared and what purpose it's being shared for. You also need to make sure that that patient can't be identified in any forum. And I say that I got a call one day from, and these are those kind of calls that stop your heart. I got a call and the person on the other end of the call says, I'm Detective Inspector so-and-so. I want to speak to Dr. Byra. Well, you know, when that happens, like, life stops being fun. And as it turned out, I said, well, this is he, what can I do for you? And they said, Doc, we've actually got a handset here that was stolen, and yours was the last number dialed, but when we see it and we opened it to look, we could see a whole lot of patients' names with all their patient details. So you need to make sure that when you're using your mobile device, whether it is your laptop or your handset, and you're using WhatsApp for your patient information, that you're using a two-factor authentication and you're using some degree of encryption to limit what that what goes over and what that patient information can be exposed to. So I would refer you back to the article earlier, and I'm sure if the registrar can hear that he would agree that that is a good orientation for you as a basis for WhatsApp. The second question was, what if you need to...
Sorry, Brad, if I could jump in for a second. I have shared the link to the article that you're referring to from the South African Medical Journal. So if everyone refers to the chat function, you'll see that there's a link there which will direct you to the WhatsApp article that they did, which Dr. Byra is referring to.
MJ, thank you so much. Jackie, maybe you want to comment on if we need to hand a patient over for judgment, and I'm assuming that's because they haven't paid. They're not going to give you consent to share. Well, actually, and Jackie will develop on this, in your informed consent, one of the things in your consent should be the financial consent that they are responsible for payment, and not that the third-party scheme or another individual is responsible. They are responsible for the payment. So the privilege that you run with your attorney in that regard is quite specific, and you're not breaching POPI by handing over the financial related information. You're not going to hand over the diagnosis and the patient's personal data around the nature of their illness. You're going to hand over the dates of your consultations and the fees that are owed. Jackie?
Correct. Brad, I can't stress how important it is to have a detailed consent form, because as this being your source document, the origin of where it all begins, you know, this is often where the problems arise later on, is how did you get that? Why did you get that? Why didn't I know you had that? So it is so important. You know, a lot of practitioners say, well, why do we have to have 5 pages of a consent form? Well, you know, we're becoming a very regulated industry, and people know their rights now. And so, you know, we need to comply. We need to make sure that there's no avenue for dispute. I am looking at a few of these comments on here, and we're trying to get through as much as we can.
Can I answer 2 as you go through this, Jackie?
Sure.
You had a question. It doesn't matter if you're a single person practice, you run the practice by yourself, or you have a team of people. Every practice needs an information officer. And so in your solo practice, that's you. And again, you go onto the Department of Justice site that's been shared with you, and you link yourself up as that person. The question is if we're still on WhatsApp, if you're communicating with individual patients, whilst you're not broadcasting to a group, WhatsApp is considered to be a broadcast medium where you could potentially be sharing this broader. So as long as you and the patient both understand that and you've written it into the consent, I think that's important to know. There's questions around ticking a tick box on a screen, allowing that to be informed consent. There is an act, and we won't go into it now, allowing for electronic signatures. So as long as you can get the confirmation from the patient that there is an electronic acknowledgement of your document, you're doing okay. You don't have to have what is called on the chat box a wet signature. You don't have to have it in ink, as long as you can show that it has been duly signed before you did what needed to be done. Jackie, there's other questions. Would you like to answer a few there? While Jackie's coming back to you, a question is, when invoicing patients, should their reports or invoices be password protected? Look, I think there's a degree of reasonableness, and one of the questions was, what is reasonable? If you're sending an information document, like an invoice to a patient, and it's got personal information that could be prejudicial to them if read outside of their environment, you want to take every reasonable precaution as if it was you. What would you want? So if it's practical for you to have invoices and reports password protected, you may want to do that. You need to act in a fashion that gives yourself the best confidence and your patient the best confidence that you're managing their data appropriately. If you are sharing that data broader than that individual patient, you should make sure that people who have access to that are significantly limited. So in the perfect world, the patient has given you permission to send them an invoice. They've also allowed you to contact them in terms of normal practice. And normal practice would be the settings of appointments, the communication of rescheduling, the updating on your practice information, change of address information that needs to be done. That's normal practice. And you don't have to have additional requirements in order to meet the normal practice guidelines of what you need to do. Jackie?
Correct. We're at the risk of, promoting companies that can provide you with manuals and things like that. We prefer not to promote any services directly or get into any sort of trouble, but there are a lot of companies, as you know, that are approaching practitioners at the moment to get POPI consent forms going, other things like PIA manuals. So be on the lookout for that. But we do want to just stress that every practice should, at least as a minimum, have a PIA manual on its website or available up in the room so that patients know how they can get access to information, because the procedure is not known unless they go to an attorney who will then say, no, look, you need a consent form and I can apply on your behalf. So my advice to you would be, tell them how they can do it so that you are being open and transparent in terms of POPI. Yeah, have a data privacy policy up on your website if you are going to be going electronic, or you are going to be receiving a lot of inquiries via the internet. Because as I said earlier, cookies are a terrible thing that, they spread your patient information wide and far, and we often can't get a control over that. So approach your IT people as well, if that is what you're going to be doing, and ask them how best you can limit cookies.
Yeah, there's a question there around the sharing of an individual's information should they leave the country. There's a very big difference in the world of information sharing between your relationship with an individual patient and you taking your patient database and shifting your database offshore, shifting the entire content. Now, that is slightly different from if you keep an electronic medical record. Your electronic medical records, you have a contract with your service provider who stores those records in a cloud-based environment. You're not shifting the information out of jurisdictions where the provider is not allowed to work in your environment. So I'm sharing that with you because at this point, you need to be aware that your minimums, as Jackie's just written, your PIA manual, your privacy policy, your disclosures all need to be in place, because you're running a practice where you're dealing with people who are vulnerable. They're vulnerable in terms of their health, and they're vulnerable in terms of their potential exposure to you because of the personal information. And you don't have to go and purchase a 600-page manual, but you do have to recognize that as long as you practice as a registered practitioner with the Allied Health Professions Council under the the umbrellas of the National Health Act, under the umbrellas of the Constitution and all its related legislation, you need to be compliant. It's an obligation that we take as part of our registration and as part of us working as professionals. Jackie?
Agreed. Brad, I don't have any other closing remarks at this stage, but we will definitely go through the questions after this as well, if there are any that haven't been answered, and we'll get back to everybody and perhaps even compile a FAQ if you'd like, we can distribute after this. So thanks so much for sharing your questions with us, and we look forward to chatting with you.
On behalf of all the practitioners and therapists, may I thank MJ and the team here tonight, Dr. Barra, Jacqueline, for providing a most informative and comprehensive summary for us. I'm sure that there will be many questions which still need to be answered, but thank you very much for your time tonight.
Oh,
Thank you, Dr. Melinda, for the opportunity to address your members. There will be follow-ups to all of you who have already emailed us, and through Dr. Melinda, we'll also make sure that we share the necessary links to the things that we've spoken about this evening. So
maybe while we have somewhat of an audience, could I just say that the method of communication from Council House is by bulk email. Unfortunately, if your ISP provider decides that that is spam, it is blocked. I try my best, but please just be on the lookout for bulk emails from Council House. Thank you.
Fantastic. Brad, any closing remarks from your side?
Thank you, MJ, and Dr. Melinda, thank you for your comments. I think it highlights very much two key issues that I want to close with. And the first issue is that it is our responsibility as individuals to stay up to date. There's a saying in some of the legal areas that says, ignorance is not defense. So you can't say you didn't know, and because you didn't know, you didn't have to do it. We are expected to know and act in accordance with that. And second, in a case like Council House, where you know reasonably that you should be getting communication, it's also your responsibility as a registered therapist or practitioner to follow up and say, hey, I haven't had communication for a while. Why is there no communication? What am I missing? And that's the same with the storing of devices and consent. There is a question that keeps coming up around consent and says, well, do I need to get consent? Again, every time you change the nature of what you're doing with that patient or their family as a user, you need to inform them of what you're doing. You need to inform them of their risks. You need to inform them of their alternatives, and you need to give them the autonomy to make that informed decision of yes or no. So you don't have to get informed consent at every consultation. But if you haven't seen a patient for a number of months, or in a case like POPI where things are significantly changing, you should take the reasonable precautions to make all of that that information available to patients so that they can decide. MJ, thank you, and back to you.
Thank you, Brad. All right, everyone, so that wraps up the talk from Genoa Underwriting Managers. Just as a closing remark, we are a medical malpractice provider. I'm sure that you can tell from the quality of the information that we've shared with you this evening that we're on top of our game. So for those of you who are looking for medical malpractice, please will you make contact with us on the email address provided, which is info@genoa.co.za. Thank you so much and have a great evening, everyone. We look forward to hearing from you. Cheers.